kick it off now. We'll keep it fairly interactive today because we're a small group, so we'll keep it informal and feel free to ask questions along the way. Introduce myself, I'm Des Leckerman, I'm the CEO of TIG, and today we have Alan Calder, who is the chairman and founder of IT Governance, GDPR specialists. He's going to tell us all about what we need to do and the I's that we need to dot and the T's that we need to cross. But before I hand over to Alan, I'm just going to introduce the event, just really frame why we're all here today. So, pick this information up from a recent Gartner review. They're saying that 92% of US organisations consider GDPR right at the top of their protection priority, because all these big corporations are very, very worried about potential risk and fines to their organisation, and the directors of the business are going to be held completely responsible for that. 77% of them plan to spend $1 million or more on GDPR compliance. So whether that's a consultancy, bringing in consultants like Alan, or on technology, and also staff training, is really getting their employees aware. 50%, now this is really worrying, 50% of EU organisations indicate they have documented the sensitive data they have, so the other 50% haven't really bothered. So that's kind of worrying. So all our personal information, and we'll go on to classify, and Alan will classify what is personal information, is out there in the open. So everyone likes to keep things simple. You need to look at the technology and the people in the organisation, look at where the risks are, and try and get some early wins in, and then leverage guidance from experts like TIG on the technology side and IT governance on the compliance side. Thing is with GDPR compliance, whenever you talk to someone, a business who's running the business or a business person, and you talk to them about compliance, you get a glazed look a lot of the times, because it's not really on the top of the agenda. They just want to move business and win business and grow the business. So, discover where the personal data is that you're holding, where it resides, and it could be on an endpoint device, it could be on a server somewhere, it could be in the cloud, and it's really difficult to do that outside of your organisation if it's in a software as a service in a SaaS application. But once you've found that where that personal data is within your organisation, then you can decide how it's accessed, how it's used, and what policies you want to create. And both using technology and also training and awareness for the people internally inside the organisation. And then once you've done that, put in rules and policies of how you want to protect that data. Do you want sensitive information going around to all groups, or do you want to limit that? And can you secure digital content itself, Word documents and Excel, and put some policies around that? And then look at how you would respond to data breaches and other vulnerabilities, and how will you present that back to the business to get the business to invest in the solution for some of this stuff. Because getting the business to invest is probably the hardest part. I mean, I was talking with a CEO of a business who it's got 450 employees, global organisation. I said, look, you've got to upgrade your security systems. This is what we've presented. And he said, well, in the last 5 years, nothing's ever happened. We'll review it next year because it's just extra expense. We'll save that £100,000 and add it back to the bottom line. But a few weeks later, hit by ransomware, and then all of a sudden it was urgent. So people only think about it after the fact. Do proper documentation reports on audits and what you're doing, and keep that in the log. So TIG are a Microsoft Gold Enterprise partner, and we specialise in Office 365 security and Microsoft Azure. And Microsoft has spent a lot, millions and millions of dollars on GDPR compliance and looking at how technology can help solve some of those issues. So, busy slide. The data and the access is coming from several different places. So, on an endpoint device, whether it's a phone or a laptop or someone's home PC or whatever, then you can manage that with Intune, Microsoft Intune, which is part of the Enterprise Mobility Suite. Authenticate the users using Azure Active Directory. Add in multi-factor authentication, where they'll get a code message on their phone. Look at things like cloud app security, so discover who's uploading what documents to what software as a service providers like Dropbox or Google that IT or the business isn't aware of today. You can discover that. Then once you've discovered it, you can decide how the business wants to set policies around that. Is the business okay allowing users to upload documents to their own personal Gmail, or are they not okay? And what documents are they allowed to upload and use? And then Azure Information Protection is going down at a granular level of what type of documents I want to set policies for. So, can I forward this document? Can I print it? Could it go outside the organisation? Because even if someone sends it outside the organisation, if it's got Azure Information Protection on, they won't be able to open the document because it'll be encrypted and secured. And then the advanced threat analytics. Really, that links in with the management suite. So looking at threats and attacks coming through, and people trying to break into your systems. So, in all organisations, and everybody themselves shares data all around the place. So it is, it is all over the place, from your offshore support teams if you don't do offshore development, subcontractor companies that you might use, project managers. So whether it's corporate remote teams or offshore teams, it's very, very difficult to control where the data is at the moment without any technology in place. So EMS is a suite of software that helps secure information on-prem and in the cloud. It allows to grant access and permissions to the data depending on user groups. It also gives you as a business who's doing what in the organisation with SaaS applications, because that's really an unknown at the moment, and detecting data breaches before they actually become successful. So finding out where the attacks are on your network, and who, where they're coming from, and what you need to do to remediate that before it becomes a problem. So we'll go into this a bit more in depth later on. What is personal data? And I was talking with somebody before, and what's the classification of personal data? Well, I think, and I might be wrong, that personal data is anything with your name on it, your date of birth, your home address, IP addresses, device names, type of thing. Sensitive personal information is political opinions, religious beliefs, trade unions, really health. What's your medical history? That's what I consider sensitive personal data. But it's about classifying both sets of data and having different treatments for it. So the Enterprise Mobility Suite is really broken down by protecting at the front door with Azure Active Directory, with secure authentication, multi-factor authentication. Protect the data anywhere, so whether it's in the head office, in the on-prem, or whether it's remotely, using Azure information protection, so protecting those documents. And then cloud app security, which is about setting a discovery of who's using what SaaS applications, and then setting policies around that. And advanced threat analytics, which is about spotting the threats before they become an issue for the business. So that's, to drill down even more on Office 365, EMS, E3 and E5. Those are the differences. So the difference between E3 and E5 is that in E5 you get advanced information protection 2, which is being able to encrypt files, Word files, and Excel files. And you also get the cloud app security. So been asked to do a quick overview on TIG. So we're a managed service, cloud services business. We're one of Microsoft's tier 1 CSP providers. Business is growing really quickly, about 25% year on year. We are managed directly by Microsoft, and we're directly provisioning on the Azure platform. We've got 73 people, 24/7 support and managed service. Our clients include some quite big brand names, but medium, mid-market sized businesses. And we're 27,001, so we eat our own dog food, so we've been on the security journey. And I was going to do a presentation today on how we've implemented security within our business, not just technical security, but actual instill it within the people, and making sure that their behaviour changes around that. It's really important for us, especially with the type of data that we deal with. Some of our partners and some of our customers, and some of our awards. And Virgin Limited Edition. So we look after Branson's Zachariah, they're a case study. Quite high profile, high net worth, high maintenance client. So that's it from me. Any questions on that? So now I'm going to hand over to Alan.
Good morning. So this is a first steps to GDPR compliance talk. So I'm going to go through the first steps. If you know most of what I'm saying, just make a sign saying, speed up, move on, stop wasting our time, please. My background is neither technology nor law. GDPR is a law, so law is quite an important part of getting to grips with what you need to do. But I'm a businessman. I ran the company that was certified for the first time to what's now called ISO 27001 back in the late 1990s. So from a business perspective, I've been involved in information security, cybersecurity, data protection for something like 20 years. I set up IT governance in 2005 in the belief that for security to work inside organizations, boards would have to get involved. It's the only way in which decisions get made, money gets committed to projects, and the business has become a one-stop shop for pretty well everything to do with people and process around cybersecurity and compliance. So we deal with not technology, but getting the people right, getting the process right, because no technology does the job that you want it to do without people who know what they're doing and without processes that ensure that things are done the way as a company you want them to be done. So we deal pretty well with the whole range of cyber resilience, information security, cybersecurity, business continuity, data protection, penetration testing, incident response, all of that host of things. We deliver those services both direct and through partners, and we've got quite a lot of activity around the other side, the service management, making it possible for people to access and do what they need to do. And we deliver what we do through a comprehensive range of stuff, starting with things like books and documentation toolkits. We've got a comprehensive public training program, so we were the first organisation to produce a certified GDPR practitioner qualification. It's now, I think, the biggest selling GDPR practitioner qualification in the UK and I suspect Europe. And we have, of course, an incredibly fast-growing consultancy team. So I'm going to talk very briefly about GDPR, its transition timelines, how it sits in law, what it really means, the kinds of measures that organisations need to put in place to comply with the regulation, key practices to approach compliance, and then a bit of a look at what a step-by-step process might be. It's important to understand the difference between directives and regulations, not just because of GDPR, but because of what's coming on down behind GDPR. A directive is something the European Commission issues. It depends on member states to turn it into law. The current Data Protection Act in the UK is the UK's response to the European Union's Data Protection Directive of the late 1990s. And that means that when a directive is implemented, the minimum requirement of the directive has to go in, but member states can do whatever they think appropriate in addition to that. A regulation, on the other hand, goes into law exactly as it's written. It doesn't require enabling legislation in member states. It simply becomes a law as it's written. So the current data protection bill, which is proceeding through Parliament, isn't something different than GDPR. It's simply the UK's government saying, let's A, give some certainty about what happens where data protection is concerned beyond Brexit, because when the UK withdraws, assuming it does, from the European Union, all of that body of law becomes a problem. So the logic is that the data protection bill will ensure GDPR is enshrined in British law beyond the date of Brexit, but it also includes what are called derogations. There are a number of areas in GDPR which allow member states to decide how they want to tackle specific issues. One of which, for instance, is the age of consent to online services for minors. GDPR says member states considered anywhere between 13 and 16 years old, can't be below 13. The UK has decided that it's going to set the age of consent at 13. And other member states will make different decisions. So it's an example of the way in which GDPR, which is supposed to produce a level playing field across the European Union, in fact won't. What it will do is it will produce a mostly level playing field with a number of little bumps in it, which have been put in to allow the requirements of member states to be reflected in the legislation. So GDPR, as the R indicates, is a regulation. So it's going to go into force irrespective of the data protection bill. It would be going into force in May next year. The way data protection works is, under GDPR, it starts with data subjects and says data subjects own their data. So from a legal point of view, there's no longer really a question as to whether data subjects own their data or not. They do, it's theirs. Therefore, it's up to them what happens to that data. And if you, the data controller, and the nature of the data controller and data processor are both clearly defined in law for the first time. A controller is an organisation that determines the means and purposes of processing. A processor is a third party that processes on behalf of a controller. It's a critical relationship, as you'll see, because GDPR says processors can only do stuff if they have a contract with a controller. Anything that a processor does where it thinks it's a processor but it can't identify a contract that it has with a controller to do it, it will be acting either by default as a controller or illegally. And the obligations of a controller are significant, and I'll come back. So a data controller has specific duties which it owes to the data subject in return for the data that it collects from the data subject. And I'll look at some of those duties shortly. And the duties include security, but they include a number of very specific legal requirements around on what basis you're processing data, how long you keep it, how accurate you keep it, and so on. GDPR allows for the possibility that your data might come not directly from the data subject, but from third parties, either because you buy mailing lists or you collect it off of social media. But it says there are specific things you have to do with data that you've collected from third parties. You can't simply collect it and use it on account of the fact the data subject might not be expecting you to do that with your data. So GDPR deals with that. It deals with the relationship between you, the controller, and a third party, and it deals very specifically with requirements around protecting data when it moves outside of the country within which it's collected. This is not a big shift on from the current Data Protection Act requirements, but the big change is in and around the fines that can happen and the impact on organisations operating in the cloud. Enforcement is carried out by what's called a supervisory authority. Every member state has a supervisory authority. In the UK, it'll be the Information Commissioner who enforces the Data Protection Act. And the ICO has powers of assessment and enforcement. They can carry out investigations, they can apply the law, they can force you to do whatever it is they think is appropriate. And they'll apply it to the data controller, not to the processor. processes act under contract from controllers. Controllers are accountable to data subjects and to the Information Commissioner for what they do. It's a very important core concept of GDPR. Individual supervisory authorities can't do essentially what they like. GDPR is meant to be a level playing field. So the European Data Protection Board, which will come into being towards the final months of this year, its role is to ensure that the interpretation and enforcement of the law around the European Union is consistent. Beyond Brexit, this all gets to be slightly muddier, because even though GDPR becomes part of British law, the reality is the Information Commissioner will no longer be a supervisory authority of a member state. And that means all the things which the ICO can do today as a supervisory authority in a member state, it will not be able to do beyond Brexit. All of the movement of data between the UK and the rest of Europe will become a legal problem after Brexit in a way it isn't now. So you need, as you're thinking strategically about what you're doing with personal data, to have very clearly in your mind the planned March 2019 departure from the European Union for the sunny uplands of dealing with India and China. Comes into force in May next year, and the key scoping questions start with the requirement that any organisation inside the European Union is captured by GDPR. And it's captured in respect of any personal data that it processes, irrespective of where the data subject lives or their nationality. So if you're a controller in the UK and you've got people from India buying stuff from your website, they get exactly the same protections as do people from France or Estonia. There is no differentiation about nationality or place of residence in terms of the definition of a data subject or the obligations of controllers. So personal data of EU residents, you don't have long to make sure that you're in compliance. It's going to be applicable to all organisations, controllers and members in member states as written, and as you know, by the 25th of May, so we're 13 months.
Sorry to interrupt. You said something about the data subjects being in different parts of the country. So for example, if a data subject is in India, do we still need to provide them with the data subject requirements as to how we're going to process the data?
If you're a controller in the European Union, yes, they have exactly the same rights. The law doesn't say EU citizens are protected, it says data subjects are protected, and then it defines elsewhere what it means by data subjects from a geographic point of view, and says specifically without considering nationality or place of residence. So it's pretty black and white from the way we see it. So this came into force in May last year. So there was a 2-year transition period. There are people who still hope there'll be a transition period beyond May 2018. There won't be. That's the date it comes into force. That's the end of the 2 years. And that's the date on which you have to comply, not the date after which you have to comply. And that means all the data which you're processing on the 25th of May, you need to be processing in compliance with GDPR. It's no good saying from that day we'll start doing it right, because the reality is all of the data you've got, you might not from that day on be legally allowed to process. So the reality is you've got to start probably months ago getting yourself compliant, because you've got to go through the exercise of getting all of the personal data you're currently holding compliant with the requirements of GDPR. So natural persons have rights around their data, they own it, they're entitled to have it protected, they're entitled to have the processing of their data protected, and they're entitled to unrestricted movement of data within the European Union. And it applies to any data that's processed in automated means or is going to be part of a filing system. That means that a pile of business cards in the corner, which you've got to go and sort through if you want to find something, that would be out of scope because it's not a structured filing system. As soon as you put them in a Rolodex, it's in scope. A Rolodex is a structured filing system because you can go through and find cards alphabetically. GDPR applies to paper records and digital records. It's not digital records only. So one of the challenges that you're going to have is thinking about what do you do with the vast quantities of paper documents that you've already got. Most organizations have got huge quantities of job applications, of CVs, which have come up in paper form and are stored in boxes, in archival storage all over the place. Most of that, when we get to look at the data processing principles, you shouldn't have. So GDPR covers all data, irrespective of whether it's digital or analog, wholly or partly by automated means, and it's in a filing system or intended to be in a filing system. I touched on the idea if you're a controller in the EU, it applies to you irrespective of where the data subject lives. If you're a controller or a processor outside the European Union but providing services into it, you also have to comply. And the definition of providing services at the moment in GDPR, just bear in mind that GDPR is a law, and therefore quite a lot of the interpretation of GDPR will depend on court cases that take place over the next 10 or 15 years. So everything that people like me say to you today is a current pre-coming into force understanding of the law. Everything can change because there will be lawyers who will bring actions who will say, we don't believe that's what it means, and ultimately the ECJ will be making decisions as to what particular clauses mean. But that doesn't help you today. Today you have to do the best you can to comply. You can't say, well, I don't really know what this means, so I'll wait until someone brings a court case and then I'll comply with whatever it is, because you might be the court case. So you've got to get on with compliance. So if you're providing services into the European Union, and that is simply defined as if you have a website, for instance, and you offer delivery into the European Union from America. Even if you only have one customer, the very fact that you are offering a service into the European Union means you're caught. If you're processing data in the in the US because you own a company in the UK or somewhere in the European Union and you run payroll in the US, you're caught. You're processing the data of EU citizens or EU residents outside the European Union. So it's in effect the first global data protection regulation, and that's partly why you see the statistics about US organizations worrying about getting GDPR compliant. We had a client in the health sector who came to us about 6 weeks ago and said, we need help, we've just decided that GDPR matters to us, we've got a whole bunch of subsidiaries across Europe, what should we do? And we talked them through a plan. We said, to give you some pricing, we need to know how many subsidiaries and how many employees in each. To which they said, we'll come back to you. And they then spent the night on the internet trying to find out what their subsidiaries were so that they could tell us the next day what they thought their organization looked like across Europe. Because they worked out that if they didn't get all of their subsidiaries compliant, the fine might be levied on the parent company, not on the individuals. So it suddenly shifts the whole bit of thinking from a group and a holding company point of view around how much do we need to worry from it doesn't matter at all, because if anybody finds out it's only a small fine, we'll argue about it, to actually this is potentially quite significant. And it's potentially quite significant because while there are two levels of fine, up to 2% of total worldwide turnover, the higher level, which applies to breaches of principles, human rights, data subject rights, and transport and processing, goes up to 4% of total worldwide turnover. Technically, of course, fines can only be applied to the entity that breaches the law. But the wrinkle is that if the supervisory authority believes that the subsidiary wasn't able to invest what it should have invested because the parent company didn't allow it to make budget available, etc., then actually it's the parent company that might be liable for the fine, which is why you see parent companies beginning to worry about what happens in their subsidiaries. 4% of global turnover is a significant hole in a bottom line. A personal data breach is anything. There's a couple of key definitions in GDPR. Personal data breach is one. Accidental, deliberate compromise of the confidentiality, integrity, or availability of personal information is a personal data breach. I deleted a file by mistake is by definition a data breach. You need to get that clear, because as you begin talking to processors or to controllers, depending on where you are in any particular processing relationship, being clear about who reports which breaches to whom is a critical part of compliance. We'll touch on risk assessment. Not all breaches have to be reported by controllers, it depends on the risk there is. But processors, by law, have to report every breach to a controller. There's no opportunity for them to decide that one doesn't matter. If there is a breach, the reason why GDPR matters is twofold. The first is that you have to report breaches. As a data controller, you have to report breaches. As a data processor, you have a breach, you have to tell the controller with whom you have a contract. The processor has to do that as fast as it possibly can. Typically, 72 hours would be a maximum period. The controller equally has to report to the supervisory authority that it's had a breach within 72 hours, but faster if possible. That means if you have a breach, you can no longer go, let's not worry about it. You might, but the other thing that will happen is that a data subject, and data subjects have rights, their rights entitle them to bring an action either through a supervisory authority or in a court for breach of their rights. So the decision you have to make from a risk point of view is, are we going to report this breach or not? Nah, let's not do that. What's the possibility of one of the data subjects whose data has been compromised bringing an action because of the compromise? And if they bring an action because of the compromise, what's the possibility that that will trigger an investigation by the ICO? What I can tell you is if it triggers an investigation by the ICO, the fine will be based not on the breach, but on the fundamental extent of negligence around GDPR. And the ICO has been crystal clear in saying that fines will not be based on the minor things you do, it will be based on the outcome of an investigation into the extent to which you've complied with your entire obligation around GDPR. So it's about accountability, it's not about box ticking GDPR. It's a very significant change in terms of compliance. Data subjects we touched on, the law says very clearly data subjects have rights around consent, access, the right to rectification. I'll come back to some of these. Where you're relying on consent, they've got a right to withdraw consent, they've got a right to lodge a complaint, they've got the right to know about automated processing. They have rights. And you can't hide the rights in a complex legal document that they can't read or understand. There's a GDPR requirement that you facilitate the exercise of data subject rights, which means you have to set out clearly what they are and tell the data subjects on whom you're collecting data how you will help them exercise those rights. There's a specific fine attached to not doing that. It's one of the higher tariff fines. And if you have a look at GDPR, you can download it from the European Commission website. It's not complicated, it's written in pretty clear English, and you can read it. You'll see there's a very clear tariff. It says this breach, that breach, that breach, 2% is the maximum. These breaches, 4% is the maximum. So, where the rubber, if you like, hits the road for any organization is once you've worked out what personal data you're processing, and the step of doing that we call a data inventory, you need to map the data flows, but for all of that data, you need to make sure that you're complying with the 6 data processing principles. So if you think of GDPR as being the critical areas, the 6 data processing principles, the 8 personal rights, and transporter data flows, you get that lot right, your fines at least are then going to be in the lower level, not in the higher level. The data processing principles start with the requirement, and these are very similar to what's in the Data Protection Act at the moment. So in theory, you're already doing this. In practice, most companies in the UK aren't. Must be processed lawfully, fairly, and in a transparent manner. Lawful is a very key word. It says that there has to be a proper legal basis for you processing data. And Article 6 of GDPR sets out what the possible legal bases are. One possible basis is consent. Consent in most instances shouldn't be your default go-to lawful basis for processing. And the reason for that is that consent, once given, is entitled to be withdrawn. Consent has to be freely given between equal parties. That means an employer can't rely on consent to process the data of employees, because employees are not in an equal position in relation to consent. So if you're going to look at your employment contracts, you're likely to see that in there is a clause which says, and you consent to us processing your data for whatever purposes we see fit. You need to change all of those before May next year because it's invalid. Under GDPR, it's invalid. An invalid basis of consent means that any processing that you've done is illegal and the data subject is entitled to have it removed. That can make employing people kind of difficult. So you're going to go for, where employers are concerned, the second in the list, which is processing data in order to fulfill a contract with the data subject. But that doesn't apply to everything, because there's some data you're going to get from the data subject because you have to, like payroll data, like data to provide the tax man around national insurance. And you're going to collect and retain that data for the third reason, which is in order to fulfill a statutory obligation. What that means is for every bit of data you're processing, you need to break it down from we get this whole set of 28 different elements. There are only, this 28 different items breaks down into maybe 5 or 6 specific sets of data, and you need to know what the lawful basis for processing each of those sets is. Yeah. And that's why you needed to start 18 months ago. It's a really, really big job of work. And what you can't do is say, we're going to collect all this data from you, and we're going to collect all of it, 3, 4, 5 different things, and we're going to ask you to consent to all of it. Because the data subject might look and go, well, I'm happy with this and this, but not with that and that. GDPR says specifically you can't bundle data. You've got to give a data subject the rights, or you've got to identify a lawful basis for each of those elements of data. And the data subject has to be able to say, I consent to that, I consent to that, I don't consent to this, without them being penalised. I'm not at any moment, you must understand, telling you I think GDPR is great, I'm just telling you what it says. So the business of working out the lawful basis of processing is a major piece of work that you've got to do. You've got to do data inventory, you've got to go and look at how you're processing the data, a data flow audit, and you've got to look at the lawful basis of processing. What really helps you determine the lawful basis of processing is the second principle, which is that data has to be collected for specified, explicit, and legitimate purposes. Legitimate is a defined term, it's a legally defined term. Legitimate, for instance, means that if somebody says to you, send me some information about a fridge, you're entitled to send information about a fridge. You don't need to then ask them for consent. They've asked you for the information. You've got, in law, a legitimate basis to send them information. The good news is that direct marketing is identified as a legitimate purpose of processing in GDPR, but legitimate is closely defined. So you can, without asking their permission, send them information about fridge support contracts or about things to put in fridges. There's a legitimate reason for doing that. But you can't send them information about a stove or a holiday, because logically the data subject won't be expecting that. They ask for information from you about a fridge. And so GDPR says in considering whether you're using legitimacy as a lawful basis of processing, you have to consider carefully exactly what you're doing. Having considered it carefully, you can do it. And for many direct marketing organizations, the amount of time and effort which has to go into working this out, again, is huge. Most direct marketing organizations, as far as we can see, are hoping that the law is going to change in some way that enables them not to have to think about this, because it's complicated. But it isn't going to change. It took 5 years to create. The chances of it being changed between now and May next year is kind of about zero. The data that you collect has to be adequate, relevant, and limited to what's necessary for that purpose. So we want to collect data from you in case we need it. We're going to keep your data in case we need it is out, because it doesn't meet this limited to what is necessary. It's very difficult to say we might need it is a necessity, because you don't know what the need is, and therefore it's not explicit. But the accuracy where necessary kept up to date and obtained only for as long as necessary. Necessary is in relation to the purpose, not necessary in relation to how long you think you want to keep it. So if the purpose for collecting data, for instance, is to consider whether you're going to employ somebody or not, they've sent you a CV, the purpose for collecting that data is to determine whether or not you're going to employ them. If that's your purpose, you've got a legitimate basis for doing so. When you decide you're not going to employ them, you no longer need the CV. The purpose for which you collected it is past. You should be getting rid of the CV. You might have an additional reason of saying, I'm also going to keep the data for a year in order to make sure I don't have to reject you again. I've got a legitimate reason for doing that. But I'm only going to keep your name and this details, I won't keep all the rest. And then at the end of the year, you need to get rid of it, but the data subject has to know.
So where you've got statutory timeframes within which to keep certain documents,
Mm-hmm.
what do you do in that case?
You keep them for that time frame. So that's why if you go back to the definition of the lawful basis of processing by data element, some of those will be, I'm processing the data because I've got a statutory obligation to do that. And therefore the retention period relates to the purpose for processing, which was the statutory obligation, so it's the statutory retention period. Most organizations need to be spending quite a lot of time between now and May just deleting stuff, putting boxes of records through shredders, getting rid of data that you don't have. And the reason you need to do that is that when a data subject comes along and exercises their right to find out what you're doing with their data, you by law have to tell them everything, including the stuff that's 15 years old. Now, remember, data subjects have a right to bring a case, and they have a right to bring an action for non-financial harm. Non-financial harm means when I found that you've been processing my data going back the last 20 years, I was so upset I couldn't eat, put me off my sex life, been signed off work, and only a large lump of financial compensation will make me better. And there's no ceiling on the compensation that a judge can award. Do you think there's likely to be lawyers offering to help people deal with their sense of being upset? Yeah. So get rid of data. GDPR allows class actions. get rid of data you shouldn't have. You have a major data breach, you sure, because the opportunity to charge somebody a 10 or 12 quid or whatever it currently is to give them their data is wiped out. They get it for free. You're going to have people exercising their rights. And there's a breach, they're going to say, fine, I've had a breach, now I want to know about all the data you've got going back forever. Must be processed in an appropriate manner to maintain security. So everything that you're hearing about earlier on is beginning to talk to the sixth principle. And it's a data protection regulation, so protection is fundamental to it. But it's not just about security, it's law encompassed in a security framework. But you've got to get all of the legal stuff right. You're going to be breached, I'll tell you that now. You have been breached, you might not know about it. What you want to do is make sure that when you're breached, you're able to demonstrate that you are in compliance with the requirements of GDPR. You want to do that because of what's effectively the seventh principle called accountability. GDPR says the controller should be responsible for and be able to demonstrate compliance with the requirements that is accountable for putting those 6 data protection principles in place. What the Information Commissioner said about that back in January was this is it's not just a box-ticking exercise. It must work on a framework that builds a culture of privacy inside the organization. GDPR mandates comprehensive but proportionate governance measures. Governance means the board needs to pay attention. There needs to be a framework that works through the organization. The board can't go, this is just an IT issue. This is just a data compliance issue. It's a board issue. If you've got a board that's saying, we're not sure about that, just sit them down and get them to look at that single sentence. Proportionate but comprehensive governance measures. A change to the culture of an organization, that isn't an easy thing to do. It's certainly true that accountability can't be bolted on. It needs to be part of the company's overall systems approach to how it manages and processes personal data. So if you think about how most organizations now deal with health and safety at work, it's kind of part of how the organization thinks about most things. GDPR is even more significant than that in terms of the extent to which it has to go into an organization's culture. It's not a bolt-on, it's a fundamental part of what the organisation does.
So Alan, after May of next year, the hundreds of phone calls that we all receive about, we understand you've been in a road traffic accident, that's all going to disappear, they won't be able to do that anymore?
No, they can do it, they'll just be acting legally.
Right, okay.
The fact that the law changes doesn't stop people breaking it.
Right, okay.
You're perfectly entitled to say to them, tell me where you got my data.
You should put the phone down now, try that.
Of course.
And if they're recording from outside the EU, is that something?
If they're providing services in the EU, they're supposed to comply. Doesn't mean they will. As I said, this is just a law. There will be lots of organisations that choose not to comply. We think that, I think I agree with your figures. Our experience is that no more than about 40% of the UK's organisations are aware of what they need to be doing about GDPR right now.
And out of those 40%, how many are actually, at what percentage, I wonder, has got GDPR in place?
In place, almost nobody. Making reasonable progress towards maybe a third of those.
At best, probably.
Yeah. Our general guidance to clients is don't try and be compliant by May next year because you won't be. And there are lots of reasons for it, including uncertainty around the number of definitions. But the simple business of shifting from box ticking to embedding it means it's a multi-year journey. And it has to be embedded.
Plus, it's an overhead for a lot of businesses.
Sure. I think 20 million euros is probably a slightly bigger overhead for most businesses. So, what does that mean? It means from a board accountability point of view, you should have a corporate risk register. Should be one anyway, really. Corporate risk register should identify risks to the rights and freedoms of data subjects as a specific risk, not just risks to the organisation, but risks to data subjects. Somebody on the board should be the nominated accountable director, the person who's going to make sure the organisation genuinely addresses GDPR. You need somebody who's going to own at an executive level data protection. Maybe a data protection officer, maybe somebody else in a senior role. Data protection officer has specific requirements around protection and role, and I'll touch on that a bit later. You need to build what we call a privacy compliance framework. And that's a combination of a personal information management system and an information security management system. ISMS is something that ISO 27001, for instance, is a national standard for. PIMS is something that BS 10012 is a British standard for. It's the only current standard for a personal information management system. So that deals with the documentation around data protection policies. This deals with the documentation around information security policies. They should work together, they should butt together. You have to have what Article 30 of GDPR calls records of processing. You need, when you investigate, to be able to say, here is what we're processing. Here is the type of data we collect. This is the lawful basis on which we do it. This is who gets to see it. Here are the controller and processor relationships. The wrong time to put that in place is after you're breached. Yes, because that will be prima facie evidence of negligence. A data flow audit is the key way to produce the information that enables you to say this is actually what we're doing. You need to know what data you've got, where it's flowing, what you're doing with it. You need to have a cyber incident response process, bearing in mind the timetable to report breaches. How certain are you that you even know there's been an incident inside the organisation? Mostly you're not. How quickly would you be able to report a breach to the Information Commissioner? Well, the starting point is you need to know who to phone. You need to know what data to give them. And you've got 72 hours, and the time it's calendar hours, not business hours. And that's chosen because most attacks take place on a Friday afternoon. Deliberately, because that's when the IT team takes a break after its long, hard, tough week and goes home for the weekend. And attackers also know that. So they hit you on a Friday afternoon, and of course that means you've got until Monday afternoon to report. And the IT team are not there, and nobody knows what's going on, which is great for the attackers. They can get on with doing with their data what they want, and you get to work and go, eek, and now you've got to put together a response in no time at all. So actually you need a cyber incident response process, tried, tested. You need to know how to report data breaches. Saying to yourself, it's never going to happen to us, is silly. It's going to happen. You just have to have a look at the reality, the report after report, the newspaper article after newspaper article. You are going to be breached. You need to put in place a mechanism for dealing with it. Even if it's imperfect, the fact that you've got a mechanism in place means that the Information Commission is going to tick. You recognise you had responsibilities, you prepared for it. And what you're looking for in dealing with breaches, dealing with investigations, is being able to demonstrate that while you're not perfect, you've done everything you could. You haven't been negligent, you've taken appropriate action.
So does the processor have 72 hours to report to the controller?
Correct.
Then the controller's got a further 72 to report it, or is it all part of the same 72 hours? Okay.
Not entirely clear.
Right.
The safe way to interpret it is the controller's got 72 hours from the point at which the breach occurred.
Right.
Time will tell whether it's serial or parallel as a reporting process, but GDPR is not clear. Think about things like Cyber Essentials, ISO 27001. Those are all mechanisms that you can use to demonstrate that you've taken appropriate steps to secure data. What you want to be able to say is, if there is a breach, we didn't just pretend that we were secure. We didn't just go and take a look ourselves and went, hey, that's looking pretty good. Actually, we did a good job, and we've got an outside independent organisation to inspect it and give us a certificate saying you're doing a good job. Cyber Essentials is the government's basic minimum standard for cybersecurity. ISO 27001 is a management system standard. You look like you were about to.
Yeah, sorry. Simply being able to demonstrate that, okay, you've got the cyber incident response plan and you've done these various certifications, does that reduce the level of penalty, or does it actually provide a full defence against any action that might be taken?
I'll tell you in about 10 years' time. At the moment, as we read GDPR, what it says is, and what the Information Commissioner's surrounding advice is that everything that you've done to comply with GDPR has to be taken into account in determining the level of fine. So our interpretation is therefore that it certainly should be taken into account in reducing from the maximum level. And potentially, if you've done everything that you can, but you still had a breach, stuff happens, should be able to avoid a fine. But if you've got a big fine, you're almost certainly going to have lawyers involved anyway. Yeah, and they're going to be saying, we've got to say this, we've got to show that, we've got to show that, we've got to just reduce it. But that's the way the law is written. That's the tariff. And then you just try and get it down by doing everything. And fundamentally, what you want to be able to do is say, we've not been negligent. We know we're not perfect. It's impossible to be perfect. But we've put the resource in, we've managed it, we've done all of these things. Yeah, we had a breach. And once we had a breach, We responded quickly because we thought about that possibility. Because the law says that fines have to be effective, proportionate, and dissuasive. Think about dissuasive as a legal requirement for fines. That means you can't err on the gentler side. Dissuasive means they're meant to dissuade people. That's a legal requirement of how fines have to be set. Not guidance. GDPR says fines must be. But proportionate is the thing that balances it. You can't hit a business turning over £2 million with a €20 million fine, because that's disproportionate. It's got to be proportionate to the offence. And the offence is going to be around negligence, not the minor issue that turns out to be the trigger for the investigation. The reason why GDPR is a journey is that there is a requirement in the law for what's called data protection by design and by default. You have to be able to demonstrate that you design data protection into your processes. And in the next 6 or 7 months, you're going to have dealt with a couple of your processes. You're going to find out where they're not compliant. But this is saying when you start a new project, when you start a new IT project, a new systems project, there has to be somebody sitting in the project team saying, and how are we dealing with data protection? In an agile project, there has to be somebody sitting in every scrum saying, how do we deal with data protection? Got to be by default. Got to be designed into every process. You say, I'm going to merge these 3 CRM systems. Somebody has to be sitting there saying, fine, that kind of thing requires us to do a data protection impact assessment. GDPR says when you're merging systems or putting new systems in place, which are going to process high volumes of personal data, you must do a data protection impact assessment. And there is a specific way you've got to do a DPIA. So, back to lawfulness. Very high bar for consent. At the moment, we just assume across the UK that consent is cool, it's the way to do stuff. It isn't, because as I said, consent can be withdrawn. Consent triggers the right to data portability, it triggers the right to erasure. Those are legal consequences of consent. So alternatives, protecting vital interests pursuant to a contract, legitimate interests of controller. You're going to want to talk to your lawyers about each of the elements of data that you're processing to make sure you've got an appropriate lawful basis of consent. And there wants only to be one. Don't say it's consent and, because then you can bet your bottom dollar that the lawyer for the other side is going to say, but my client didn't consent. And you say, but it was also, this is a lawful basis, and the judge is going to say, yes, but they didn't consent, and you put consent in as one of the lawful bases, so I'm sorry, you're out. One lawful basis only for each element of data is the practical, sensible approach. Whatever the lawful basis is. Speak to your lawyers. As you get familiar with the logic of lawful basis, it gets easier to work out what the lawful basis should be. You want to document that. It's part of the Article 30 documentation. What are we processing? This data, that's our lawful basis for processing. Touched on controls and processes. You need, if you're a controller, and you can be, the old Data Protection Act, you would have thought of as an individual as being a controller. It's not. This is about the entity that determines the means and purposes of processing. You can, as an entity, be a controller in respect of a number of processes and a processor in respect of others. So to give you an example, an organisation that does salary outsourcing, that pays wages for other companies, it'll be a processor in relation to those wage bills, because the employee data that comes from its customers is owned by the customers, because the customers collected it from the staff. So the salary company is a processor and has a legal obligation to the controller in respect of that data. But it's also an employer. It itself employs people, so it will be a controller in relation to the people it employs, because it will determine the means and purposes of processing their data. So again, doing a data flow audit, getting clear about what data you've got, one of the things you want to flush out is, are we a controller or are we a processor? Because of the key legal requirements that controllers are responsible for ensuring processes comply with contractual obligations. Processors are not allowed to process data other than in line with a contract from a controller. It is illegal to be doing so, and therefore by default, if you can't say under investigation, this is the contract, you are by default either breaking the law or you're a controller, and you'll be able to say as a controller, I didn't know, so I haven't done all the things, so you're breaking the law. So it's a really critical area of compliance, yeah.
Sorry, another question. With a circumstance where you have a system where you input customer data in there, so for example, sanction screening or financial checks, who then is the controller in that particular situation or the processor? Is it the company inputting that data?
So who's deciding what data to collect from the data subjects?
The company is deciding what data to collect.
Correct, so you're the controller. The definition of controller is the entity that decides the means and purposes of processing. Purpose of what am I collecting and what for? If another company, a cloud service provider, for instance, is providing you a platform or a software service within which to do it, they're a processor. And they're probably only a processor in terms of providing hosting and security services. Because they're not actually doing anything with the data, you're putting it in, you're using the software they provide to do whatever it is you want to do. So you've got to think about, because GDPR is not quite on board, you've got to think about using software in the cloud in the same way as you think about using software on your desktop. It's simply a mechanism for doing stuff. You're the controller, and it's the cloud service provider is providing security, and so therefore in that sense they're a processor. In the sense that they might have access to the data because their service technicians might need to, is one of the areas you're going to need to flush out. Because if you're going to say you can have access to the data we're processing, you've got a different security problem.
And if in that situation where somebody is hosting, if their platform gets hacked, who's in breach?
Well, who's in breach is the thing you've got to do afterwards.
Yeah.
The first thing they have to do as a processor is tell you you're the controller. So your contract with, and this is one of the many areas that gets hairy, how do you go to Salesforce and say, you have to tell me within 72 hours if you have a breach?
Yeah.
And you might not be, so you might have to work out what alternative controls you can put in place. But technically, they tell you, because you've had a breach,
Yeah.
they've had a breach which has affected your data, you then report it to the ICO.
And then it's investigated.
Consent must be clear and affirmative. So untick this box if you don't want to receive data from us is no longer legal. The Direct Marketing Association hates that because it recognizes that it will have far fewer people to mail stuff to as a result. But GDPR is crystal clear. The Information Commissioner's advice is crystal clear. You can't have consent by default. Consent has to be a positive affirmative action. It can be done by ticking a box, it can be done by changing browser settings, whatever it is that's clearly the data subject saying, yes, I've decided to go ahead with this.
So buying databases to do automated marketing, email shots and whatever is going to be outlawed?
No, not at all. You can buy a database. Your challenge when buying a database is to ask yourself, what's the lawful basis on which the company from whom I'm buying it has got the data? That's question number one. Question number two is, once I know that, are they in a position where they can legally sell me the data?
So if they've complied with GDPR, then it's fine to use the data.
Once they've done that, you have to issue what's called an Article 14 privacy notice. There's Article 14 because there's two articles in GDPR which deal with what you have to tell data subjects. Article 13 deals with what you tell data subjects when you got the data from them. Article 14 deals with what you say to them when it came from somebody else. And before you do anything with the data, you send all of those people an Article 14 notice which says, this is where we got your data from. Specifically, they're entitled to know exactly where it came from. This is what we're going to do with it. This is the lawful basis on which we're going to do it.
Before you start marketing campaign?
Correct. That's why the Direct Marketing Association is saying, no, please, GDPR is really not going to happen, is it? No. Take away. But you have so your Article 14 notice will say, and our legitimate interest, because you have to have a lawful basis, is that you said to the company from whom we got the data that you were happy for people to send you information about X and we're going to do exactly what you signed up for. That's a legitimate basis. Because direct marketing is recognized in GDPR as a legitimate basis. Now, you simply send them a notice which says this is what we're going to do, and they have a right to object. You're not asking consent because you don't have to. For legitimate interest, you simply have to tell them what you're doing and tell them how to exercise their right to consent, right to object. So you send them your Article 14 notice, this is what we're going to do. If you don't like it, this is how you opt out. Most good companies will be doing that right now anyway with bought-in emailing list. It's an onboarding process about saying, this is what we got, this is what we got your data from, this is what we're going to do. We've done it for years now. And yeah, you get a number of people will opt out of it, say, where did you get my data from? I say, well, this is where we got it from, go kill them. But what you're then left with is people who are happy to be on the list. And as I increasingly say to people, why do you want to market people who don't want to be marketed to? Putting a lot of time and effort into building a database with lots of people who don't want to hear from you, just so you can say, I've got 5 million people in my database. Yeah, actually only mailing 50,000 of them, but it's a 5 million person database, gosh. So, silencing activity doesn't constitute consent. Written consent, if you're doing written consent, must be clear. You must be able to demonstrate that you got consent. So if you're doing it on a website, you need to have logs that say, yes, this person ticked this box on that day. Just as you should be doing now with terms and conditions. When people say, accept my terms and conditions to buy something on an e-commerce website, you should be doing exactly the same now with the processing that you want to be doing. A couple of key areas. Children, people under the age of 16, or depending on member state derogations down to 13, may not consent to processing of their data for an online service. It doesn't affect any other things they're allowed to consent to, but very specifically, online or what's called information age services, it's illegal for somebody to consent, and therefore for an organisation to operate on the basis of consent from somebody below the legal age that they can consent. What that means is that if you're providing services into an area which is likely to be interesting to minors, is you have to work out how to flush them out. You have to work out that when they say, no, I've got my mother to tick the box, it might just be their friend. Because you have to know if consent has to be given clearly, you have to have some evidence that the person who gave consent on behalf of the minor was entitled to give consent on behalf of the minor. So that makes life really pretty complicated for social media organizations, for any one of those organizations providing information age services to people, online gambling, for instance. It's information age service. And then the final, so that's Article 8. Article 9 says that there's what are called special categories of data. What the Data Protection Act used to call sensitive information is now called special categories of data. It includes, anything. It includes political beliefs, race, ethnic origin, health information, biometrics, genetics, the whole lot. You're not allowed to process it. The legal situation is it's prohibited unless you can identify a specific exception. So unlike the rest of data where you've got a number of grounds on which you can process it, and you're entitled to, you have no automatic entitlement in law to process any special categories of data. You have to be able to identify a specific exception to the prohibition. The start of that is explicit consent from the data subject. And explicit means something in law. It means they actually have to know what they're consenting to. So you have to say, I'm collecting your health data, this is what I'm going to use it for, and this is how long I'm going to keep it, and this is who has access to it, and this is where it's going to be stored. So I'm saying, okay, on that basis, I'm happy to do that. That's pretty well what we already do when we send an employee to have a health check, for instance. Usually the doctor won't release the information to the employer without explicit consent from the data subject.
Does that then mean that it will be a two-part? So for example, when you fill out certain forms, and there is a legal basis processing, say for example they want to carry out the DBS check for you, and then at the very end of the page they do have things like your medical history, or your gender, religion, things like that. So in that particular instance, then they need to specify why they're asking for that information. So there has a legal basis for processing, which is to carry out the checks, and the second part is to consent to that information.
Sure, and there are a number of other possible lawful exceptions, which include, for instance, vital interests of data subjects and so on. So explicit consent is just the most likely, but it's not the only option. But yes, you're right, you have to have, if you're going to process a special category of data, you have to have an Article 6, that's the normal lawful basis of processing, lawful basis, and you have to have an Article 9 exception.
Have you got are there any circumstances where you've actually got to specify a time limit for consent?
Yes.
Or
Yes.
what would trigger it?
So if you go back to the 6 data processing principles, the requirement that you process data only for so long as is necessary means you should set the retention period at the point you're determining what data you're collecting. So there's never thereafter a question. It is this data we keep for that length of time, and we build our systems to make it possible to get rid of it.
So what about you backing up, and a lot of companies keep stuff for like 7 years indefinitely, then that data's going to be in the backup.
Correct.
So how do you get it out of the backup?
Big problem.
And I mean, if we got products like Minecraft, where it is,
Mimecast has a problem. Mimecast will keep your data forever, it can't.
well, precisely that.
Impossible, because first of all, you're the controller, not them. It's your data in their email system. They're a processor, they have to operate under a contract from you. You can't lawfully allow them to keep the data forever, because the means and because the purpose of processing almost certainly doesn't include we'll keep the emails forever.
Even though they advertise it as one of their big.
They might have to stop. I cannot see a way in which Mimecast advertising will keep this data forever is going to enable them to win or keep any business from organisations that want to be GDPR compliant.
It's interesting because they put GDPR compliance as one of the reasons why people should use their product.
There you go.
It's a good product.
It's not even a grey area. It's not even a grey area. The law is crystal clear. The controller determines the means and purposes of processing. Processors have to process in line with the contract with the controller. There is no legal basis for keeping data forever.
Could be a revolution.
And if you think about it from a simple perspective, why would a data subject be happy that you're keeping their data forever? And that's where GDPR starts. It starts with, what does the data subject expect? The core of the regulation is the rights and freedoms of natural persons. It's not about the rights of organizations to have data, it's about the rights and freedoms of natural persons. So if you're ever in doubt as to what something might mean, the question to ask yourself is, if it was my data, how would I feel? If it was my brother, husband, sister, daughter's data, how would I feel? I wouldn't feel good about them doing that. Chances are it's going to be illegal. Because that's how GDPR is built. It's built out of a Central European fear of what fascist states were able to do with personal data many years ago. It's driven very strongly out of countries like Germany and Holland, which have always been much more extreme than the UK around data protection. So it's likely that places like Germany are going to have to cycle back some of their requirements to comply with GDPR.
So how would it affect Facebook and LinkedIn and that?
Massively.
I mean,
Massively. Most of their audience, as far as I can see, is about 10 or 11 anyway, apart from people who are advertising. It's the kind of raise money, give it to Facebook venture capital model. And I think that all of those kids, there's a problem. Because Facebook's processing the data illegally.
or Snapchat.
Yeah. Correct.
What is?
So I think what those organisations are going to do is they're going to try and put a plaster over that makes it look as though they're compliant, and hope like hell that it takes a year or two for the European Commission to bring a case against them.
Well, in the personal side, if you're, does it not cover, the household part, that if I'm posting a picture of you, non-corporate related, then that's my choice.
So GDPR specifically excludes any data processed in what it says a purely personal capacity. So we think that that means that what you're talking about is fine. However, if you're posting my picture and I didn't know about it, I'm entitled to get upset because you're posting it on Facebook.
I think, is it the case that you still don't have, you can ask me to do it, but you would have to contact Facebook to say, I'm not happy that my picture's gone up there, not actually anything
Probably.
against me. Yeah. I think that's how they're going to try and get around it, really.
Probably, but
Well, there's another issue. You had a friend and you posted a picture up 3 years ago, and then now you're not friends anymore. And
yeah.
like, there's it's very complicated.
As like I said, I think GDPR is going to keep the European Union's lawyers in school fees for the next 20 years. Because there are so many of exactly those issues which are going to have to get flashed out. I don't know the answer.
Is there any indication, briefly, who they're going to go after first? Is it the kind of talk breaches that they're looking at?
Well, there are different
signals
signals coming out of different supervisory authorities. The practical reality is that they're not going to go after anybody immediately, because they can't. Because you can only go after somebody for a breach. The law only applies from the 25th of May. So you have to have breached it after the 25th of May. Now, if you have a data breach due to negligence, the negligence was there before the 25th of May, they can't fine you on the basis of GDPR for something that you did prior to the 25th of May, because it didn't apply. They can only fine you for stuff afterwards. So if you fail to report a breach on the 26th of May, they can fine you for that, but not for the negligence that led to the breach, because that negligence occurred under Data Protection Act. That's, again, our interpretation of how the law works, because that's how the law works. You know, that's the law. You can't be held accountable for breaking a law that didn't apply when you broke it.
So in terms of data held, for instance, we're B2B, so we've got clients and ex-clients and stuff on our database that we've had contact with before. They've asked to receive our resales, we send them, etc., etc. But let's say we've got a lot of people on there who stop receiving our stuff, stop subscribing. After the 25th of May, do those people need to have been removed from our database, or the fact that we collected them and had them there prior to the 25th of May, is that okay?
Let me give you two bits that answer that. First is that GDPR doesn't distinguish between B2C and B2B data.
Right.
So alancorder@itgovernance.com is personal data. I have, using that email address, exactly the same rights as I might as alancorder@hotmail.com.
Which is another major change, isn't it? Because it used to be the B2B was...
It used to be, and that was because of a soft opt-in clause in the e-privacy regulation, or e-privacy directive, which is about to be updated with a regulation which deals with cookies and IP addresses in a way that also has very big fines attached to it. So that's the first thing. The B2B data is personal data, so all the same rules apply to it as apply to anything else. The second is, if somebody says, don't process my data, what they're technically saying is, don't process my data. When you keep the data in order not to process it, there's a kind of logical impossibility in that position, isn't there? So there's a decision you've got to make. Most organizations keep that list of people who don't want their data processed, so they can compare new lists and that kind of stuff and make sure that you don't send them data.
But it's also because if you've spoken to people in the past, or for example, if you've spoken to someone, they stop subscribing and said, please don't send me any more stuff. Obviously, what we normally do is make a note on that client's details on the CRM, and then reference that and see that we shouldn't contact them again. Whereas,
Sure.
of course, if you're not if they don't want their details there anymore, you remove that. You've then got no record of to call them again.
Correct. So that's also, I don't think there's a real issue there. I think it's perfectly reasonable to say, sure, we'll stop emailing you, but we're going to keep your data. Is that okay? Because clients entitled to know, or say subjects entitled to know what you've got. And they say, yeah, you can keep my data, just don't email. That's fine. You keep the data, you don't email. If they say no, erase everything, then you've got two options. One is you erase everything, and then you buy a list from somewhere which has got their name on it, and you phone them up, and they say, I told you not to phone me, and you go, but how would I know? I erase everything. If somebody says, erase it, we erase it. We got no idea of who told us not to. So this is where we got the data from. Very sorry, feel free to take action on it, but we did what you said. The consequence of you insisting on erasing it is we erased it. And you're entitled to say that to the client at the time they ask for having it erased. Your other option is to say, fine, we will stop processing it, but as long as you agree, we think we've got a legitimate interest, we think we've got a legitimate interest in maintaining the fact that you've asked us not to process your data, and we're going to keep it secure in this basis for as long as we're in business to make sure we never do it again. Because they're entitled to know, again, what's going to happen. I think as long as you do that, you're in the clear.
Essentially making sure you've got a decent paper trail and it's
Yeah,
well as well.
correct. The problem comes when you don't tell the data subject, and then your database is hacked, and that 1 million email addresses that you're no longer processing gets out into the wild. Now you've got a data breach. Now you're in serious trouble because A, your security was inadequate, B, you're processing data illegally, you've got no lawful basis for it, C, you didn't tell the data subjects. So you've got the Information Commissioner carrying out an investigation. You've got a whole lot of data subjects. Remember, the ones who said don't process my data are likely to include the ones who get a bit uppity, putting a class action suit together against you. So it's really worth thinking through exactly what you're going to do and being very clear with data subjects and having a very clear audit trail.
So you can do that. They say if my right to be forgotten.
Yeah.
But there is a legitimate reason that we believe we should hold your data in some shape or form for financial records or whatever.
Yep.
So we can just write to them and say, look, we have deleted you from our data, our data, but we do still hold a record of you for, whatever, giving an explanation of that. And
absolutely. So the right to be forgotten is overridden by an alternative reason for processing. So statutory obligation is an alternative, and that would override. So the right to be forgotten is not absolute.
Quick question. We use LinkedIn Sales Navigator.
Very good.
So what's the opt-in data permissions around that?
Well, the question is the extent to which A, people who are using LinkedIn know how LinkedIn is making their data available to people who are exploring it. B, when you collect the data, you need to tell the data subject what you're going to do. There's no stopping you collecting the data from LinkedIn, but you can't put it into your CRM system and start processing it without telling the data subject. I think you could probably say to the data subject, we got your information from LinkedIn, this is your range of interest, we're going to therefore send you information about X, Y, and Z. Because you're from LinkedIn, because it's available to us, we think we've got a legitimate interest for doing so. We won't do anything for the next 30 days. During that period, if you want to object, this is how you object. Okay, and then it's completely legal, because you've basically told the data subject, you've given them the opportunity to object. If they don't, you're complying with the law.
But as the data subject, how are you going to get, you'll be inundated with emails, aren't you?
Fun, isn't it? So again, there's going to be so there's going to be a whole series of accommodations, I think, appear over the next year or so, of people saying, actually, I don't care about that, of organisations beginning to think about smart ways they can let people consent to simple things. But GDPR has to bite before people are really going to think about how they make compliance easier. I think we're probably beginning to run out of time. Transparency is a big requirement. We have to be transparent with the data subject. If you think about transparency as applying in every single aspect, you can't write complicated legal documents. They've got to be written in simple, clear English, preferably using things like icons, anything that makes it easy for a data subject to know exactly what's going on with their processing. You've only got a month to respond to a subject access request. Can't charge a fee. Subject access request doesn't have to be in writing. That means somebody can go onto your LinkedIn account or your Twitter account and say, send me all the data you're holding about me. Your training needs to encompass making sure staff recognize subject access requests. You need to have a process which then ensures that you gather all the data, you redact it, you take out stuff that doesn't relate to the data subject, and you give it to them within the 30 days, sorry, within the 1 month, not 30 days, within the 1 month you've got to do it.
Isn't there something around you can charge for bulk requests?
You can make charges where you think the requests are, pardon me, are excessive or require vast amounts of work, but you have to justify the charge. So you can't have just as one as you actually, the lawyer specifically have to justify specifically why you're charging what you're charging. And if it's obvious that the charges you're making to try and deter the data subjects, then you would expect the Information Commissioner to give you a smack around the head in the form of a fine. Because it's about transparency. You know, you're supposed to facilitate, make it easy, all of that kind of stuff. We talked about data controllers and processors not in the EU. If you're providing services into the EU, you have to have a representative appointed inside the EU where most of the processing is taking place. We talked about data protection. Impact assessments, the reality is because GDPR applies to all the data you've got, one of the key things in your compliance project needs to be data audits. What data have we got? Where did it come from? Where are we holding it? Who owns it? And you need to look at how you're protecting the data. And the more you start thinking about protecting data at the data level, the better. Because security of personal data, of course, is the big issue. The sixth principle, data must be processed in a manner that ensures appropriate security of personal data. There's no definition in GDPR of appropriate. That's a bit of a bother. Including protection against unauthorized or unauthorized processing, etc., etc. Using appropriate technical organizational measures. No definition of any of those words in GDPR. So the fine for breaching this principle goes up to 4% of global turnover. But what you've got to do is really not clear. That's why I say it's a bit of a bother. So you've got to think quite hard about how you're going to demonstrate you're using appropriate technical or organizational measures. Our view is that things like Cyber Essentials, ISO 27001, established secure technologies are all ways you can say, actually, these were appropriate, they're technical, they're organizational measures, they protect the data. In 10 years' time, there will be a set of very clear tests that enable you to say what is appropriate. But that will come out of court cases. So in the meantime, you've got to make some practical decisions about what you're going to do. Appropriate level of security, concepts like pseudonymization, encryption should be basic. You should think of encrypting data at rest and in flight as an absolutely basic security precaution. And the reason why you should do that is because as we understand guidance from the supervisory authorities across Europe, if data is encrypted and there is a breach, there is no risk to the rights and freedoms of data subjects. Yes, there's been a breach, but you don't have to report it as a controller because it's encrypted. So your internal processes would identify there's been a breach. You'd have somebody look at it and go, yes, we see there's been a breach, and we're not going to report it because the data is encrypted. So encryption should be absolutely basic. You can think of it conversely, not encrypting as being the kind of thing that will lead to very high fines very quickly, because it's such a basic and obvious thing to do nowadays. Encryption is no longer a complicated thing like it was 5 years ago. It's no longer expensive. It no longer slows down servers. It no longer makes it difficult to get emails. It should be an absolutely basic part of what you do.
You'd be surprised how many people don't use encryption.
Sure.
Yeah, but even if you encrypt it and it's not a high-level encryption and there is a data breach and whoever's got your data has got a more sophisticated way of de-encrypting that information, does that...
So if you think about encryption, you want to be encrypting to an international standard like FIPS 140. Not any old weak algorithm. It needs to be an internationally recognized high standard of encryption.
So we use 256-bit AES. You can't crack that.
Not at the moment. And that's one of the other clauses in GDPR. It says taking account of the state of the art. You've got to determine risks. Taking account of the state of the art means today this is an appropriate control, it works, but in 2 years' time it might not be. So you have to keep on reviewing your security and making sure you're upgrading to deal with the current state of the attack art.
Should the emails be encrypted as
Yes. You know how easy it is to intercept emails? Very, very easy.
Yes.
So you've got emails which have got all sorts of information in. They get intercepted. Yes, definitely encrypting those.
And how does that work in terms of communication? If you're sending an email to somebody who doesn't have that?
Microsoft, for instance, now has a very simple mechanism that enables you to send an email that's encrypted to somebody and enable that person to sign up for an encryption service very easily so they can decrypt it. And there are numbers, you see more and more of those kind of technologies emerging and becoming basic in operating systems. WhatsApp is apparently encrypted anyway.
Yeah, there's questions about that.
Which is also an issue for the security services.
Of course. And from GDPR's perspective, the security services are a problem because they want access to data they shouldn't have access to. So keep thinking about GDPR as German-driven, and the Germans don't want anybody to get at private data at all. The big problem with the US is the Wild West. It's exactly the other end of the spectrum. It says security services should be able to access any data they want about anybody, anytime. So, security is very critical. Testing, assessing, evaluating the effectiveness of your security is critical. You can't just say we got there, job done. It needs to be an ongoing process year after year. Concept of data protection by design and by default. How long do you want me to continue for?
Does everyone want to continue? Another 20
Yeah,
minutes?
we've still got 20 minutes.
Yeah.
So I touched on privacy compliance framework. It's about accountability, so it's what the board does, the governance framework. It's about tying in the 6 data protection or privacy principles with a set of data protection policies and procedures and information security management procedures. So you need to begin thinking inside your organization about creating a privacy compliance framework. A PCF is the phrase you see increasingly. And that's the comprehensive framework driven by the board that ensures the organization is doing what it should be doing around data. Touching very briefly on data protection officers, it's a mandatory appointment for organizations processing high volumes of personal data, high volumes of special categories of data, or for public authorities. Mandatory means you have to have a data protection officer. It's a protected role. You can't fire them because you don't like their advice.
Substantial.
Yeah.
What's substantial?
Correct. That's a perfectly good question.
No idea.
Yeah. The other perfectly good question is, what is core processing? The guidance suggests that it's substantial in the context of whatever it is that you're doing. So, as an example, if you're processing the data of 500 members of parliament, that's probably a substantial number of people, given there's only about 600 of them. But if you're processing the data of 500 people who use Microsoft laptops, that's almost certainly an insubstantial number because there are millions and millions of them. So mostly the starting point is to say if it's got 5 noughts on it in terms of the number of data subjects, it's probably substantial. But not necessarily. So the guidance, our guidance always is if you're not sure, it's probably a good idea to do anyway, because then you're moving towards being able to demonstrate data protection by design and by default. And all of the things which are mandatory for some organizations but not mandatory for others actually are part of data protection by design and by default. They're part of embedding data protection inside the organization. And hey, given the complexity of GDPR, why wouldn't you want to have a DPO? You don't have to have one full-time. You can employ a DPO on a part-time service contract. You can share a DPO amongst a number of companies inside a group. There's a number of different ways you can do it to make it cost-effective. GDPR allows explicitly for all of those options. I can't think why you wouldn't have a DPO, so it's a good practice point. Lots of other people will need training, people in marketing and sales, in HR. They all need to understand what GDPR is about. Specifically, you can use certifications like ISO 27001, Cyber Essentials to demonstrate that you've taken appropriate action. The Article 40 and after in GDPR specifically says that. Doesn't absolve you of compliance, enables you to demonstrate you've taken appropriate steps. So you should be thinking, as you get further into your compliance program, about how do we add Cyber Essentials and ISO 27001 into the mix. International transfer is particularly an issue for cloud-based processing. I don't think GDPR is completely up to date in terms of understanding how stuff works in the cloud, which is a bit of a problem because you've still got to comply with GDPR. You can't say, guys, you're out of date, I'm doing something else, because that's not going to keep you out of trouble. You can only transfer data out of the country in which it was collected on the basis of what's called adequacy. And adequacy depends on the European Commission saying that country has an adequate data protection regime. Apart from the European Economic Area, there's only about 8 other countries in the world which meet that test. Not Australia, but New Zealand, I think Uruguay, all of the Channel Islands, they've got adequate data protection regimes, they're exciting. Canada has, not the United States. The United States never will have an adequacy finding. It never will have, because there is not and there never will be a federal data protection law which applies equally across the whole of the United States. It's the starting point for the European Commission, a national data protection law. So then you've got transfer subject to appropriate safeguards, which is a set of standard contract clauses that you have to have in place with any organization to whom you're transferring data, or inside international organization, what are called binding corporate rules. They're contractual obligations, 2 different forms of contractual obligation, which say that you, the controller, not only are in a position to enforce, but have a legal ground to enforce the requirements around GDPR on any processes outside the European Union. The simple answer to the question of what happens if the processor turns out to be rubbish, from the Information Commissioner's lips is, you're in trouble. You made the choice. You chose a rubbish processor, they didn't comply, you didn't enforce compliance, you're getting fined. Remember, they've spent 5 years thinking about this, so most of the ways that you might think of we can get out of it by doing X, Y, or Z, they also thought of. Countries with similar data protection regimes. For the US, there is the EU-US Privacy Shield. And the key thing to be thinking about from a UK position is March 2019. March 2019, Britain will be outside. Some people think that's so exciting. The European Union, it means that it'll no longer be lawful to transfer data between the UK and the European Union unless one of these 3 mechanisms is in place. Either the European Commission has to recognise the UK has an adequate data protection regime, which is part of what the government tells us why they are busy making GDPR part of law right now. But you've got to ask yourself, what's the chance of the European Commission making that determination in the next 18 months at the same time as all the rest of the Brexit negotiations are taking place? Because on the day Britain leaves is the day we're no longer part of the European Union. That's the day on which the automatic adequacy finding no longer applies. So you've got to think now about how you're going to process data beyond that. We set up a company in Ireland. All our post-Brexit business will be done out of our Irish business. All of our European customers, everything will be dealt with in Europe, in Ireland, with staff, everything in Ireland. Because we're assuming it's going to be a complete shambles. It's the only practical basis for planning, and the reality is that there ain't much time left for the government to get it sorted out. And from our point of view, the European Union is a very important market. We don't want to find ourselves struggling with how we move data between the European Union and the UK beyond March 2019, so we've just got on with it now.
Apparently that's why Facebook's head office is in Ireland now as well.
There's a different reason for them being in Ireland.
Ah.
Tax. It's called tax and the double Dutch. Facebook, Amazon, Apple, the double Dutch. It's that's why most of us pay more tax than they do.
So in terms of data, you were talking about where data is collected
And processed.
Yes. So essentially, I mean, for example, for us, we contact a lot of our clients are based in Europe, but obviously we collect that data from our office in the UK.
Correct.
So how does that affect the way we hold that data? So in terms of the data transfers, well, it's not transferring anyway because it's all held in the UK and collected
Correct.
from the UK. So
Correct. So you're a UK organisation.
Yeah.
Do you have other entities
We
in
have no
Europe?
European offices. We
Right,
have,
so you're providing
we have
services
local
into the
ones,
European
not-
Union.
Yeah.
So you therefore have to comply with GDPR anyway,
Yeah.
because you're caught by the territorial requirement.
Yeah.
You have to appoint a representative inside the European Union, because that's a requirement of non-EU organisations. And you have to comply with GDPR. And you have to be able to demonstrate by some form of standard contract clause that with the data subjects that you are complying with GDPR.
For example, if they set up an office in Dublin and then had hosting, all the applications, the database was hosted in Dublin, then that would probably...
As long as you're not accessing it from the UK. Because then you're processing it in the UK. Accessing data is part of the definition of processing.
When you say
Looking at data is
What
part of the
about
definition of
viewing it?
processing.
Not-
Looking at it is processing.
When you say you have to have a representative in Europe, do you mean just like you could just have a room somewhere with one person for a company, or do you mean?
Not clear. GDPR just says you have to appoint a representative in the area where most of the processing is taking place in Europe. So you'd say actually most of the customers we're dealing with are in Germany, so you appoint a representative in Germany. The representative is there, so data subjects can contact someone inside the European Union, and a supervisory authority knows who to go after.
And you can do that because we have a base in Ireland and here, so we could assume use a representative in Irish.
What you would probably do is you'd put in place binding corporate rules between Ireland and the UK, which would enable you to comply irrespective of whether there's an adequacy finding or not. Which is why I say if there's no adequacy finding, you're stuck with one of those sets of lawful bases. And they're much more complex and expensive to put in place than, gosh, it's adequate. So supervisory authorities, their role is to monitor, enforce, communicate, promote awareness, do all of those good things. They have powers to investigate, correct, advise and enforce. Different supervisory authorities are making different noises. The ICA is currently saying we're going to use fines as a last resort. Other supervisory authorities are saying we can't wait. The role of the European Data Protection Board is to make sure that that's consistent. So I think that the people who say we can't wait to give big fines will have themselves knocked down a bit, and the ones who say we're going to be very gentle for the first little while will find they don't get away with it, because the European Data Protection Board's job is to make sure enforcement is consistent. Because if you think about it from a free common market point of view, it would be very easy for one country to say, come to us, we don't enforce GDPR at all. And everybody would move from Germany to the UK. It's a bit like saying, come to us because we're only going to charge 4% corporate tax. Like Luxembourg. You can, if you're operating across many countries, you've got offices in a number of countries, you can select one supervisory authority as your lead supervisory authority. So you don't have to deal with 3 or 4 or 5, you can deal with just one. The supervisory authority has to be the supervisory authority of a member state of the European Union. So if you choose the information commissioner, that's really neat up until March 2019. After that, Britain won't be a member of the European Union, so if you're processing inside the European Union, you'll need a supervisory authority inside the European Union, not in the UK.
So again, the same would apply for
Absolutely. You put binding corporate rules in place, and I would suspect you choose the Irish commissioner as your lead supervisory authority.
even beforehand.
Yeah, absolutely. Most of the stuff, as I said, the really important thing is May 25th is by when you have to comply, not after when. So you need to be getting compliant now. There's nothing in GDPR which, if you comply with it now, will undermine your Data Protection Act compliance. So get on with making the changes now. Change the lawful basis of processing, get rid of data you shouldn't have, start identifying who's going to be your lead supervisor. Put all of that stuff in place. Binding corporate rules exist now, standard contract clauses exist now. They're all there right now. You can use them right now. You want to get to May next year and go, first phase done. We've got the core stuff in place. Now we can get on with putting data protection by default and by design in place. So that's the European Data Protection Board, have a level playing field. And the approach to compliance, hope isn't it. So I think that is where this is meant to end up, steps towards compliance. Don't hope it's going to be all right on the night, because it's not. I'm absolutely certain that none of your organisations will currently be compliant with the Data Protection Act, because organisations just don't bother in the UK. The gap, therefore, GDPR builds on the Data Protection Act. If we're not compliant with the Data Protection Act, the gap is huge. It's a project, it's a big project. It will require money, time and resource to get compliant. Starting point is a governance framework. Make sure the board is aware, make sure that there's a risk register, there's a proper accountability framework, you've got a director who says, we're doing this. My neck is on the block to make sure it happens. We need a program to get us there, with a proper project plan, which enables us to know what we're doing. Money committed, timeline, all of that normal project stuff. It's a business change project. Appoint a data protection officer or a senior data protection officer of some sort, but put somebody with sufficient legal and practical experience in charge of the program. A data protection officer is not somebody who's just been on a practitioner course. They actually need to know the law. GDPR sets out for data protection officers, says they need to have, they don't have to be lawyers, they need to have a good working knowledge of data protection law. They also need to have practical knowledge of things like information security and privacy and documentation and penetration testing, and how to do the things that enable the organization to know that it's compliant and to deal with breaches. Put somebody in the role of data protection officer. Put money and resources into the project. There are organisations, even the UK newspapers are beginning to identify that larger organisations are putting millions and tens of millions of pounds aside now for their GDPR compliance programs, because they've suddenly recognised, eek, this is expensive, and actually doing it right is less expensive than getting a fine. Because if you think about getting a fine, that doesn't absolve you from ever having to comply. You get a fine and you still have to comply. So you could be like TalkTalk, where you have a breach, you ignore it, you have another breach, so you ignore it, then you get a fine, and then you ignore it, and then you get another fine. Okay, the only thing that's going to happen after GDPR is those fines won't be hundreds of thousands, they'll be tens of millions each time. So TalkTalk wouldn't be in business right now if GDPR was in force, because it was so evidently negligent in dealing with issues the first time round. Anybody who can put a chief executive in front of a television camera who says, I kind of don't have a clue.
She's still the CEO. She's still
yeah, absolutely.
running the company.
Yeah. Wouldn't wash. So data inventory. What data have you got? What shouldn't you be holding? Data that you don't have a lawful basis for processing, that's beyond its retention date. Work all that stuff out. Get rid of it now. Work with your partners. Whoever's helping you, IT managed service providers, work with them. They're helping you manage data. You're the controller. You can't turn to a managed service provider and say, it's your fault I got a breach. You're the controller. You have to be on top of what's going on. The exciting thing is your service providers are obliged legally to help you comply with GDPR. Have to help you. They can't say, actually have to help you. So get on with it, get some help. Don't forget the shadow IT, all of the IT operations that people inside the organization are pursuing because IT is too complicated a team to deal with. There's all the apps which they've downloaded or they're operating, they haven't told you about. The company's still processing personal data through all of those. You're not going to be able to run a defense which says, I didn't know the marketing team were using that application, I didn't know they were collecting that data, we're off the hook. The Data Protection, the Information Commissioner says, no, negligence is what you're on the hook for. You should have known. So don't forget shadow IT. Use a data discovery tool. Make sure you build with sustainability in mind. It's the start of a long-term inventory process, not a simple snapshot. Data flow audit. Data flow audit says, where does the data come from? What's happening to it? What assets is it being processed through? Who accesses it? What's the lawful basis for processing? How are we retaining it? It tells you the 6 data processing principles in relation to everything that's happening inside that data flow. You don't need to do data flow audits for simple data flows. There's 10 people's data being processed, and there's only 2 steps. That's kind of self-evident. It's the complicated processes where you've got lots of people's data. A recruitment process is quite a complicated process. You've got data coming from multiple sources, from recruitment agents, from individuals applying for jobs, from people referring it. All of that's providing personal data, which might go to individuals inside the company or to HR. It goes somewhere. There are interviews, people make notes. Any one of those steps could lead to a breach. So you might say to somebody who's applying for a job, Article 13 privacy notice, we're going to collect this information in order to make a decision about whether to employ you or not. This is the only information we're going to collect. Then they go to an interview and somebody says, and tell me about your sex life, or tell me about your health, or whatever it is they choose to do. And maybe the interviewee is silly enough to provide the information, which gets written onto the CV. That wasn't in the privacy notice. So you've got somebody collecting data that was not in the privacy notice you gave the data subject at the beginning. And therefore your processes don't deal with how do we retain that data, what happens to it afterwards. A data flow audit is designed to make sure you pick out all of that processing, enable you to go and change what people do if you need to, but enables you to get compliant. You need, across the whole of it, to make sure that all of those information flows are secure. You can then look at the rest of your compliance, or you can do that in parallel. Have we got a proper subject access request process? How do we deal with incident response? What privacy notices do we put on our websites? What is our Article 30 documentation that proves that we've thought about how we're going to record processing? All of that is part of what comes out of a compliance gap analysis. In the critical processes with substantial volumes of data, do a data protection impact assessment and security gap analysis. If you have to, you have to. There are specific processes where it's required. It's a good thing to be thinking about doing for high volumes of data in any case, because it's what drives privacy by design or data protection by design and by consent. So identify where a DPIA would be appropriate or mandatory, and then get on with remediation. Build the privacy compliance framework, make sure it works from the board down, make sure that all the documentation is in place, look at external security certifications, make sure that the technical security measures are in place, that they're delivering the level of security that you actually want. Make sure your incident response and data breach reporting process works. So write it, imagine all the scenarios within which it might have to work, and test it. You don't want to be testing it for the first time when a breach occurs. When a breach occurs, one of the requirements of GDPR is that somebody on the breach team observes everything you do and makes a record of how you've responded to help the investigation later. So you really don't want to be working it out all the time, because one of your own teams will say, we didn't know how to do this, and we made that up, and we got that wrong, and then we did that, and that's going to go to the Information Commissioner for part of her investigation. Much better to work out in advance how to do this stuff. Monitor it. You get to compliance or something that looks like compliance. You actually need to stay there, because GDPR is not a destination, it's a journey. So you need to be able, as a board, as a management, to make sure that you're continuing to be compliant. You need to have ongoing internal audits. It needs to become part of whatever your internal audit framework is. Your management system should be built into ISO 27001, 9001 audits. Those all involve personal data, should be built into that. Should be doing penetration testing and security testing. As the ICO says, yes, it's going to cost money. Gives you better compliance, should give you a competitive edge. So that's all to the good. You can present yourself on what a good person you are. However, if you don't want to do that, we've got a really big stick. And as we've demonstrated in the past, we're very happy to use our stick, because while we wouldn't need to, Last year we issued more than £1 million in fines for breaches. We were only allowed to fine up to £500,000, that was our maximum, and we could only issue fines after somebody already had a number of breaches or we'd issued a compliance notice. That's changed. We can now issue fines when you're in breach. We don't have to tell you to comply before we're allowed to think about giving you a fine. Our enforcement powers aren't just for typical data breaches like laptops left on trains or information left open to a cyber attack. The GDPR gives regulators the power to enforce in the context of accountability. Data protection by design, failure to conduct a data protection impact assessment, data protection officers and documentation. The business can't show that good data protection is a cornerstone of their practices. They're leaving themselves open to a fine or other enforcement action that could damage bank balance or business reputation. I can't think of a better place than the ICO's own words to finish this session on. Any other questions?
Stumped. Everybody's stumped.
Good luck.
Scared.
No, scared's good. Scared's good. There's lots of stuff which, that of course we can do to help. Manuals, pocket guides, gap assessment tools, training, certified training courses, consultancy support, lots of stuff you can get from us or through our partners.
Thank you.
Thank you very much.